Hey guys, my name is Rheannon Simmonds and I have recently joined the conveyancing team at Enterprise Legal as their Senior Conveyancer, and I will be assisting clients with selling their properties. So the purpose of today's video is to not only introduce myself to you all, but to also discuss the recently released REIQ contract for sale of house, land and units. Some of you may be aware of the changes already, but here at Enterprise Legal, we wish to make the process of buying and selling as seamless as possible for our clients. So we have been working hard to develop many different resource information to provide to you about the changes. So as we all know, from the 1st of January this year, all houses and units for sale must have compliant smoke alarms installed on their property. So if you are unsure if your property has compliant smoke alarms, please follow this link attached below to the fire and rescue website to ensure that your smoke alarms meet the standards. If you aren't sure if your smoke alarms are compliant, you can arrange for an inspector to visit the property to deem if they are compliant and to provide you with a certificate that we can provide to the buyer. If you're unable to install compliant smoke alarms or choose not to, the buyer is now entitled to a 0.15% reduction of the purchase price at settlement. So as a seller, it's important to consider whether the cost to install the smoke alarms would be greater than the possible 0.15 reduction of purchase price, and that's really up to you to decide. But to ensure that the smoke alarms meet the requirements, we have prepared a special condition to cover off that. So there is now no need for a seller to provide a certificate of no poor compliance to the buyer, but they just need to disclose this at the time of signing the contract. If this is done, the buyer will then have no termination right. On the flip side of this, if the seller does not disclose that there is a certificate of no poor compliance at the time of signing the contract, they will be required to provide this to the buyer before settlement and arrange the certificate at their own cost. The buyer will then have a termination right if this is not provided. So there is now an option in the new contract for either party to request an extension of settlement of up to 5 business days at any point, including right up until settlement that afternoon. The extension can only be for a maximum of 5 business days and can be requested at any point and automatically given, but only applies to settlement extension requests and not to standard conditions such as building and pest or finance. So this one does scare us a bit, thinking of the potential repercussions for our clients, particularly those purchasing, worried about the fact that there is really no certainty now on settlement date. And potentially, if you're purchasing, you could be stuck wanting to move in and have to extend your settlement if the request is made. So we have prepared a special condition in regards to this, and this is available on our website that we have been recommending to our clients and agents to avoid this potential request being possible. There is now a termination right for the buyers when it comes to infrastructures relating to the property that pass through the property and that service not being protected by a registered easement, BMS or statutory authority. It is very important to undertake a search like dial before you dig, as the buyer will now have the option to terminate the contract if this information is not provided by the seller. So one of the things you will see on your contract is the location of settlement, which is normally just a suburb that the agent lists on the contract. The parties will then liaise as to where the settlement will actually happen, and it's normally dependent on the seller's bank or the seller's solicitor. This condition has now been amended to state that if the exact location, meaning the solicitor's law firm, has not been advised to the other side by at least 2 days prior to settlement, then the settlement will then take place at the local titles office. So because we often can't finalise the exact location of settlement until sometimes the day of settlement due to many different reasons, and besides the obvious inconvenience for all parties and the uncertainty, we also don't think the titles office would be too keen on having us all convening out there either. So again, on our website we have drafted a special condition to combat this, which we are recommending to everyone and is available for use. So this amendment to the contract for the settlement location of course does not apply to PEXA settlements, but with the fact that PEXA is not yet mandatory in Queensland, we can never be certain if we can settle via PEXA. So it's always a good idea for us to include this just in case. So there is a lot of things to consider there within the new terms of the contract. At Enterprise Legal, our fixed fee does include a high-level review of the draft contract prior to signing. So given all the points that I have raised today, I do think it is imperative for you to ensure that you try and send the contract through to us for review, and we can request any applicable special conditions to be inserted. If you would like any assistance with the purchase or sale of your property, or have any further questions, please feel free to contact me and the rest of the team here at Enterprise Legal on the contact details below.